residential foreclosure actions and why it's a timely topic. And also, as Rebecca mentioned, both Sarah and I are litigating these issues right now. So, of course, even following this webinar today, if you have questions, feel free to reach out to us. So I'm going to do the first half of the presentation, and Sarah is going to cover the second half. And we're going to take a break in the middle for questions. And, of course, we will address questions at the end as well. Okay. So today, this is our agenda. First, we're going to talk about, what is the actual time limitation for mortgage loans, what causes the statute of limitations to run. We're going to talk about acceleration, which is one such event that can cause the statute to run. We're going to talk about how the statute might be told, when acceleration might not actually be acceleration, and deacceleration, what that means and why that could be a problem. We'll talk about quieting title, which is a way to actually, cancel and discharge the mortgage, the statute limit, if the case is time barred. We'll go over some practice tips and address the free house objection, meaning that, sometimes there's criticism that it's not fair for a borrower to get a free house as a result of the statute of limitations. So critics view it as unfair, so we'll go over how to respond to some of these concerns. So why is this important, or why is this a timely topic? Well, as we're aware, the foreclosure crisis began about 7 to 8 years ago as a result of predatory lending, coupled with the economic downturn. And even though a lot of our clients may have, be in default since that time, there are a number of homeowners who don't have current foreclosure actions pending. Perhaps the bank never actually been in some of those situations. Maybe there was a prior foreclosure action which was either dismissed by the court or discontinued, perhaps because of standing issues, or the case may have sat for years in the shadow docket, and the bank has delayed bringing a new action. So as a result, many of these homeowners have lived in a state of uncertainty for years, but luckily, they might have a valid defense to actually save their homes. So everyone's favorite person, Bruce Bergman, we decided to provide this slide to show that, the statute of limitations is not an issue that, is just on our radar. The plaintiffs' bar has been aware of this issue as well. They acknowledged it, as early as 2005. So, we just include this slide to show that the statute of limitations is a valid defense, and, it's something as well. So as you're aware, the statute of limitations is a procedural statute that prevents a party from enforcing a cause of action that may have accrued when that party sits on its claim. And it exists for, not just mortgages, but pretty much any cause of action. And, it doesn't determine the merits, but cuts off the right to file suit on that claim. And in New York, the statute of limitations is embodied in New York CPLR 213-4, and the statute of limitations is, the period is 6 years. So, we provided the language of the statute. So as you can see, it's pretty broad, and it includes commencing a foreclosure action or even just suing on the note. So when does the statute of limitations begin running? So there are 4 main ways, as this court pointed out. So it can begin running 6 years from the due installment. That's each monthly payment, or when the mortgage comes due, when the mortgage has been accelerated by a demand, or when a foreclosure action is filed. So again, for any mortgage payable in installments, there are separate causes of action for each installment accrued. So each monthly payment, there's a separate cause of action. So technically, if the loan is not actually accelerated, the bank can be barred from collecting any payments that came due more than 6 years ago. And this slide basically says that as well, where the entire mortgage has not yet come due. A mortgagee will only be barred from collecting principal and interest payments due more than 6 years prior to the commencement of the foreclosure action. And these two cases that are cited down below, in both of those cases, the loans were accelerated through foreclosure filing, so there is no demand letter sent prior to the commencement of those cases, and the courts there, they both found that only the portion of the debt that was barred was the amount that came due more than 6 years prior to the action. So the entire debt was not barred, only those payments that came due more than 6 years prior. Okay, so next, when does the statute begin running on the entire mortgage debt? The statute begins to run on the entire debt either upon the loan's maturity, so at the end of the term, or once the mortgage debt is accelerated. Now, we've also included this minority view slide. I would take this with a grain of salt. When we did review the decisions, there were some decisions that we came across where the court didn't refer to acceleration. They just talked about the debt being time barred from the event of default. But it's possible that it was just poor drafting. You know, these decisions seem to be outliers, and really it should be not the point of default, but the point of acceleration that you focus on. So that begs the question, what constitutes acceleration? So in order for a loan to be accelerated, there has to be either a notice of election to accelerate, or there has to be some overt act. This can be in the form of a letter. It's not enough if the mortgage document itself contains, some language about steps that a bank can take to accelerate at its option if the lender doesn't actually, take those steps and overtly accelerate the loan. And again, or not again, but the acceleration must be clear and unequivocal. So in this case, the Sarva case, even though the mortgagee sent a letter, had admitted sending a letter stating that he wanted to get paid in full, the letter was not entered into evidence, and the borrower actually admitted that he never saw a letter and didn't actually know that the loan had been accelerated. So the court found that the loan had not been clearly and unequivocally been accelerated because there was no evidence that had occurred. And again, a loan can, by commencing a foreclosure action, that it can accelerate the mortgage, and possibly also if an acceleration letter is sent, though that happens less frequently. One reason for that is the way a lot of the mortgages are drafted. They're not actually required. Of course, you have to look at the mortgage. The bank might not be required to actually send an acceleration notice, so that's why we often see acceleration through the commencement of foreclosure action more than an actual acceleration notice. But again, in order for the acceleration notice to actually create an event of acceleration, it has to be clear and unequivocal. And we gave you an example of one case where the court found that the loan was not accelerated because the letter that was sent was determined to be just a default letter, not an acceleration letter, because it indicated that the failure to pay the amount due may result in acceleration. So that language that said may result in acceleration, not this constitutes acceleration, was not enough to qualify as an event of acceleration. An illustration of how acceleration might work. So in this example, the homeowner defaulted on November 1st, 2007, and the lender brought a foreclosure action on May 1st, 2015. So that's a 7.5-year period between the event of default and the commencement of the foreclosure action. So if the loan was accelerated before May 1st, 2009, then the action is time barred because that would be more than 6 years prior, and it should be dismissed with prejudice. But if the loan is only accelerated upon the commencement of the foreclosure action, if either there is no prior foreclosure action, this is the first foreclosure action, or a letter was not previously sent, then the mortgagee will only be barred from collecting the principal May 1st, 2009. So the bank will only be barred from collecting the installment payments that came due more than 6 years prior. And often, the complaint will allege either that the plaintiff accelerated through the commencement of the action, or might possibly identify an earlier acceleration point based on the mortgage's election. Perhaps even attached to the complaint, if you might find that the lender attached an acceleration letter, even if it's not. Even if the date is not listed in the complaint itself, you might find the letter attached. So that could be helpful in determining when the loan was accelerated, if it was accelerated at an earlier point. And it doesn't matter whether the bank right now was actually the bank that previously accelerated, as long as the predecessor in interest properly accelerated the mortgage, then the loan was accelerated. And again, one thing to be aware of, though, is whether that predecessor in interest had standing to actually commence a prior action, because that is an issue that we'll talk about in a little bit. So another issue that's come up is it's possible that acceleration can be revoked. However, if the borrower changed his or her position based on the acceleration, then the Court of Appeals in this slightly old case did state that the mortgagee can't revoke as long as the mortgagor changed its position. So we don't really have good examples of what the change in position could be, but perhaps it's if perhaps if the mortgagor tried to sell the property, if they took on more debt or borrowed money from family or friends, those might be some positions that in some ways that the mortgagor has changed his or her position based on the acceleration, which would prevent the bank from revoking acceleration. So assuming no reliance on the acceleration, it's possible that that the acceleration could be revoked by an affirmative and unambiguous act. But we say theoretically, because no court that we were able, no decision that we came across has found such a revocation resulting from a mortgagee's act. So it's unclear what those affirmative and unambiguous acts would be. But the decisions do talk about what is not an affirmative act. And while it's possible, that a court might interpret voluntary discontinuance to be an affirmative act, at least the cases that we came across, the examples that we provided here, in those situations, the court said that was not an affirmative act that qualified as revocation. Obviously, if the court dismisses the case, that's not an affirmative act that the mortgagee took. We provided some cases as well where the prior cases were dismissed after a mistrial or failure to appear at a required conference, or if the court dismissed the prior action for lack of personal jurisdiction. And acceptance of a partial payment also is not enough to revoke acceleration, nor is delivery of a new 90-day notice, because the banks are required to send that by statute. And if a bank is successful or does take an affirmative step to revoke, in order for the revocation to be valid, it has to occur within the statute of limitations period. Okay, so when acceleration is not acceleration. So courts have rejected statute of limitations defenses upon a finding that the bank did not actually accelerate, the acceleration was ineffective. And as we'll discuss, unfortunately, standing is one such issue, which is really unfortunate because many of us have had great victories for our clients and get us for standing, but unfortunately, even though the prior cases were dismissed, the courts have interpreted that the commencement of the prior action was not actually valid acceleration. And we have two examples of cases where, unfortunately, that's the case. So in Wells Fargo versus Burke, in June 2002, the bank brought a foreclosure action, and then after commencing the foreclosure action, then the note and mortgage was assigned to the bank. So after the bank was alerted to the standing issue, the bank voluntarily discontinued the action and then brought a new action in August 2000, 7 years later. Now, if it was a different situation, it would appear that the prior commencement of the action would constitute acceleration, but unfortunately, the court held here that service of the 2002 complaint was ineffective to constitute a valid exercise of the option to accelerate, because the bank didn't actually have the authority to accelerate at that time. This is another similar case, the Suarez case. Another entity attempted to accelerate the debt on April 8, 1997 by commencing a foreclosure action. However, again, the note was not actually assigned to that entity at that time, so it didn't have the authority to accelerate the loan, and so the court, again, here held that the purported acceleration was a nullity because the statute of limitations did not actually begin to run on the entire debt at that time. So unfortunately here, the subsequent action was held to not be time barred. However, the court did note, as we discussed previously, that the recovery was only limited to the unpaid installments that came due within the previous 6-year period. So it's also possible that the statute of limitations period could be reset. So the statute of limitations can be waived or reset by a promise to pay the mortgage debt. This is provided under New York General Obligations Law 17-105. So a waiver of the expiration of the time limited for commencement of an action to foreclose a mortgage of real property the statute of limitations can be waived, but it has to be signed by the borrower, it has to be in writing, and it has to include express terms. So as you can imagine, this can be a problem where there's a settlement agreement or a loan modification or perhaps a bankruptcy plan. However, in the bankruptcy context, it's possible that New York General Obligations Law might not be implicated if the bank rejected the bankruptcy plan. So in Albin versus Pearson, the borrower filed a bankruptcy plan in which the debtor agreed to make payments on the mortgage. However, the bank rejected the plan. So the court there held that the bankruptcy plan did not constitute a promise to pay under New York Obligations Law 17-105. However, in a different case, Albin versus Delacroix, there the bankruptcy was found to have satisfied the criteria of the New York General Obligations Law because it was signed by the borrower. It expressly promised to pay the mortgage, and unfortunately, there it did reset the limitations period. And so we also just wanted to highlight that lenders might argue that a forbearance agreement or a trial plan also constitutes a waiver to reset the clock. But in order for a promise to pay to restart the limitations period, it has to be an express promise to pay or an express acknowledgement of the indebtedness. And it also has to be it has to have an absolute and unqualified acknowledgement of the amount paid, which is certainly not the case in trial plans or forbearance agreements. So I think at this time we're actually going to take a break and see if there are any questions, and then Sarah is going to take over for the second half of the presentation.
Okay, so there's one question that has to do with bankruptcy, and I think you may have answered it, but if we need to come back and circle around to it at the end, we can. The other question is there a way or possibly a document that lawyers could file to prevent interest and other fees from accruing if the mortgage company has not accelerated the loan?
Okay.
So this is Sarah. Hi, everybody. Randy may have some thoughts about this, but I would say if it's not accelerated, there's nothing to impede the homeowner from making payments unless the homeowner can't afford to do so. But the bank would not, if the loan had not been accelerated, wouldn't be rejecting payments. I don't think there's an argument for why the principal and interest and the interest and fees would not be accruing under those circumstances. I mean, you can always dispute fees because sometimes they're junk, but I don't think you can dispute the accrual of interest, especially if it's accruing according to the mortgage.
Yeah, I think I would agree with that.
Right. I think the point of the question, I suspect the point of the question is these cases that are just hanging out there, the lenders are refusing to do anything with, that perhaps it's along the lines of a zombie property, right? Maybe the person is still living there, they're trying to work something out, but maybe they're not accepting payments, but they haven't officially accelerated the debt, although that is an interesting twist. But certainly, I don't think that this isn't the way that you're going to be able to fix it, I think is the short answer to that.
Right, and if the bank is rejecting payments when it hasn't been accelerated, I think that's the basis for a complaint. I mean, all of this stuff is the basis for a complaint. Certainly, junk fees, and I think you could complain to the CFPB. You could escalate. You could complain to financial services. There are a lot of places you could go if it seems like what's accruing is improper.
Right, but I think that's the biggest part, and you've spent some good amount of time identifying what is acceleration and figuring out whether, in fact, they have accelerated, and then taking it from there. So let's see. So we have a few more questions now. Is there a statute of limitations issue for cases in which a summons and complaint have been filed, but the lenders have not taken action to prosecute those cases ever since, including not filing the RJI?
There's a basis for seeking dismissal based on neglect of prosecution, sort of a separate thing, but absolutely. I mean, in some courts there's actually a mechanism to get cases dismissed if there's been no activity, but the court can sua sponte discontinue a case if there's no action after a certain point. And there is a rule about filing an RJI at the time that the affidavits of service are filed. So there's a basis to move to dismiss if that hasn't been done.
Yeah, absolutely. The case would have to be dismissed first before you'd be able to. The bank would have to then would have to attempt to file a subsequent action. But if it's not time barred in this action, you'd have to try to get it dismissed first. And I think failure to prosecute is a really good way to try to do that.
It doesn't squarely fall into the statute of limitations area, but everyone recognizes that there's a real problem with limbo, and some of those issues have been addressed, statutorily and through rules, court rules, but it still can happen that cases end up sitting after getting after just the summons and complaint and the answer have been filed. And it remains a problem because there may not be all that much motivation for the banks to seek modification or some other solution. So our clients are getting charged excessive interest. These are a little outside the purview, but
okay. So let's move on. We have two other questions that I'd like to raise. So the first one has to do with some clarification on acceleration, what acceleration is. Is commencement of a foreclosure action different acceleration than the acceleration of installment payments? Because in a foreclosure, the bank can collect the entire amount and wouldn't be barred from collecting the last 6 years' worth of payments. So then why in the EMC versus Suarez case did the court find that the recovery was limited to payments within the 6 years prior?
So it's funny, we were actually talking about this morning. So, we didn't come across any cases where the loan was accelerated by a letter, for example, an acceleration letter previously, and then only the last 6 years were allowed, that the more than 6 years were time barred. But it might be different, and if that's the case, I haven't seen any cases where the installment payments due more than 6 years were barred. But certainly, if a case is commenced and there is no prior acceleration, the law does seem to be clear. There were numerous cases where the installment payments that were due more than 6 years prior to that point of time were barred.
And this could kind of come up in a couple different ways. Not that we've seen it, we can just imagine it. But one could be, for instance, supposing someone defaults and the bank waits longer than 6 years to file a foreclosure action, commence the action and accelerate. I mean, the acceleration is calling the entire debt due and payable, and you know, the likely outcome if someone can't resolve it through some solution in settlement is, you know, if it goes to judgment of foreclosure and sale, it gets auctioned, and we're not really talking about, you know, waiving payments. But I guess if it gets that far, then the referee, when he or she computes, is excluding those payments that would have been due, you know, more than 6 years prior to the commencement and the acceleration. Again, that might not be that salient a situation or very relevant, but another situation just might be, you know, resolving through some kind of reinstatement. Maybe the reinstatement would exclude the pre-6 year payments. That may not, you know, again, that might not make that big a difference, but it could. You know, also there could be a situation where instead of suing in foreclosure, the bank might sue on the note, and in that circumstance, we're not even really talking about acceleration because we're not talking about calling the entire debt due and payable. We're just talking, I guess, about the note. Maybe it's acceleration. It's hard to know how you calculate that. But in any event, if someone's suing on the note, the amount of the note that's owed is definitely not going to include whatever payments, post-default payments preceded the 6 year period. So those are some scenarios, but it's not like we see those every day.
So somewhat related to what you're just saying, is the statute of limitations on both enforcement of the mortgage lien and the underlying promissory note so that neither a foreclosure action or an action for payment of the note can be brought?
That's correct.
Okay, right.
Yeah, it covers both.
Great. Okay, so I think we're good for now.
Okay.
Okay. I will continue on. Okay. So we were talking a little bit about, you know, about whether that general obligations law 105, I'm sorry, would cause the statute to reset, and that is sort of related to this issue. What if someone tries to make payments after the loan is accelerated and the bank actually accepts those payments? Does that revoke the acceleration? Would that reset the acceleration period? The answer, at least according to the third department, is that the acceleration is not revoked if the mortgagee accepts additional payments. In this case, Latin v. Amicus held that if the bank accepted these additional mortgage payments after it said it wasn't going to, that's still not inconsistent with the idea that the bank really wants the entire debt paid. So accepting payments just because it, you know, it's just because it accepted those payments doesn't mean that it also hasn't accelerated. So there could be a lot of different circumstances where this comes up. Obviously, we know of plenty of cases where someone's making forbearance payments, trial payments, etc. after acceleration. Those, if the third department is, you know, holding is also adopted by other courts, we haven't seen it one way or the other, the bank should not then be able to argue that that the acceleration has been revoked if it is for some reason forced to discontinue the action and start anew. This CPLR section 204 also relates to tolling of the statute. It's related but different from the general obligations law. The relevant text of the statute is here, where the commencement of an action has been stayed by a court or by statutory prohibition, the duration of the stay is not part of the time within which the action must be commenced. So this is related to the bankruptcy question that someone posed earlier. So you had sort of one part of that question answered perhaps by the discussion of general obligations law. CPLR 204A deals with the commencement of an action being prevented by a bankruptcy. So there could be other stays, obviously, in place, possibly, by the death of the borrower or something like that. But Strawbridge here is a Southern District that a case that discusses this issue. So there were a lot of stays due to bankruptcy as well as state court stays, and because even though 11 years had passed since acceleration, the statute of limitations had actually been told for all but 2 of those 11 years. So in this case, it looks like the acceleration occurred, and then that acceleration wasn't effected by the commencement of an action. In other words, this might have been an acceleration by notice rather than by commencement of an action. And so that's one circumstance, and it probably doesn't happen all the time, where an acceleration occurs and then the commencement of an action is stayed. So this next case illustrates that distinction. So in Beneficial Homeowner Service Corporation versus Tovar, the bankruptcy did not stay the mortgagee's ability to commence an action because the action had already been filed, I believe. It had already been commenced at the time that the Chapter 13 petition was filed. So because of that, there was no tolling. So just for PLR 204 has to do with the commencement of an action. It doesn't have to do with the tolling of a statute after an action has already been filed.
Could we pause for a minute? Can you expand a bit on the stay as a result of the death of the borrower?
So, so really, and this is actually, it's a little, this might be procedurally complicated, but so if the borrower dies before the foreclosure action is commenced, then that action would be a nullity and would be due to be dismissed. So it's hard to imagine really, that there would be a proper stay in place, because a stay would only really be proper if the case had already been brought and then the borrower died. So there may be another situation where there would be a state court stay, and it's hard to, I guess it could be, for instance, in a case where there was another case pending and subsequently there was an acceleration. Subsequently, the borrower died, and subsequently there was a desire to bring that borrower into the existing action. Look, I don't actually, I can't remember the procedural posture of Tovar, but or the Strawbridge case. But there could be any number of reasons why a case is stayed. In the case of the death of a borrower, though, the stay is only appropriate if the case has already been brought. So that wouldn't bring the death of a borrower into the ambit of the Strawbridge example. I hope that was clearer. Did I cover the question?
I think that might be a question that Jackie can raise directly with you. She actually has asked if she can have both of your email addresses, so I'm hoping that will be offered at the end for everybody.
Indeed. Indeed, and I mean, not on our PowerPoint, but we're very happy to share our email addresses.
Okay, so I think we'll leave it at that for now.
Okay.
Thanks.
All right. So here are a couple other cases that explore the wrinkles of CPLR 204. Saini is a case we discussed earlier, and really all that these cases reveal is if there's a stay and then the stay is lifted because of a discharge or for other reason, and the bank has the opportunity to commence a foreclosure action to accelerate the loan, then they really have to do that. If they didn't have the opportunity because of sort of perpetual stays, then that's one thing. But if they had the time, if they had the opportunity to commence an action, then they can't benefit from the tolling that may occur, for instance, if there are two separate bankruptcy proceedings. You know, for instance, in Saini, there was an action discontinued before the bankruptcy was commenced, and then the bankruptcy petition was dismissed. There was another foreclosure action filed. They could have actually begun that second petition well before, the second foreclosure action well before the bankruptcy petition was filed. So there was no basis to toll. And in Mercury Capital, there actually was a time bar. The bankruptcy stay tolled the statute from the filing of the bankruptcy petition to the confirmation of the plan. So that was only a year and 4 months, but the plaintiff waited 7 years and 7 months to start the foreclosure action, so they were 3 months late, essentially. 1 year and 4 months subtracted from 7 years and 7 months is that sticky 3-month period that they had, and they squandered. Okay, and here's another aspect of the bankruptcy tolling nexus. This is the case National Loan Investors versus Pichatello in the Second Department. So if the lender accelerates the debt, then the running of the time period can be told if the homeowner subsequently commences a bankruptcy action, acknowledges the debt, and promises to pay. This is basically GOL 17-105. But remember, if the homeowner gets enters into a plan, that is the acknowledgement of the debt that resets the clock. But if the lender doesn't accept the plan, there is no reset. It's the same old statute of limitations that started when the acceleration occurred. Now, fraud can affect the statute of limitations, but really it just boils down to the defendant doesn't get to benefit from his or her own fraudulent conduct or wrongdoing if that wrongdoing led to the delay in bringing suit. So it's simply an estoppel argument. It's more in the realm of equity than anything else. But if the defendant acted fraudulently and yet it didn't actually prevent the plaintiff from starting a timely foreclosure action, then that fraudulent conduct doesn't actually implicate the statute of limitations. The defendant could still invoke that defense. All right, here's another little tolling law, and this is something like a little bit of a safe harbor period. CPLR Section 205A allows the bank to up to 6 months after one action is dismissed or terminated, I should say, before starting another action. So supposing the action was accelerated, the mortgage was accelerated by the filing of a foreclosure action in 2008. There was a termination of that action. We're not in trouble so long as the new action is brought within 6 months. The lender has a little bit of a safe harbor, so that statute of limitations defense is not available, except if the action was terminated under certain very common circumstances. If the lender decides just to discontinue the action, they don't get that 6-year period. They're kind of if their papers are not in order for whatever reason, they're stuck with the statute. So if they discontinue and then want to start a new action after 6 years is run from this acceleration, that new action is time barred. If the bank never obtained personal jurisdiction over the borrower, there too, they're not entitled to that safe harbor. Of course, we're talking about a very lengthy period of time. If there was a problem with personal jurisdiction, it would kind of be surprising if the bank didn't know about that issue after 6 years had passed from acceleration. So that both of these reasons for terminating smack a little bit of neglect. So we might just sort of be looking at neglect in a sort of a broad sense. But the third category is the broad neglect to prosecute. So if the bank sits on the case, doesn't move forward, and then the court says, I'm discontinuing this action for want of prosecution, starting again, the bank might be too late. Okay, so here are a couple of cases that illustrate these issues. So there was tolling in the recent case, U.S. Bank versus Galarmo. The plaintiff had not established standing, and that's why the case was discontinued. It's kind of interesting. The court said, sorry, you haven't established standing, therefore I'm dismissing. The bank then got its act together, I suppose, and filed another case within 6 months, and that was determined to be timely. However, if the bank itself voluntarily discontinued, realizing that it can't prove standing, can't make its prima facie case in order to get a judgment, then it wouldn't be entitled to that 6-month safe harbor. So just a little observation there. Now here's a really tricky piece here, and something to really pay attention to if you're actually litigating on behalf of a borrower. Now, neglect to prosecute is one of the exceptions to the applicability of CPLR 205A, but the court actually has to make a record of the specific conduct constituting the neglect. And if that doesn't happen, if the court doesn't make that record, then there may not be actual neglect to prosecute for purposes of the statute. So, if the case is discontinued and the court says, it's because of neglect to prosecute, that may really not be enough, and the bank still may be able to use that 6-month safe harbor. So, if you're actually representing the borrower in such a circumstance, it might be worth, definitely would be worth your while. There's a statute of limitations defense that you could invoke in a second action to ask the court to make a record. Just a little practice tip there. All right, switching gears, we've been talking all about the statute as a basis for dismissing a case, but there's this other aspect to the statute, which is if there's an acceleration, if the bank essentially had the right to enforce the mortgage, which it does if it accelerates, and then it doesn't enforce the mortgage within the 6-year period of time, the mortgage is due to be canceled. The mortgage and the note are due to be canceled of record. So the statute is New York's Real Property Actions and Proceedings Law, 15014. So when the period of the applicable statute of limitations has expired, anyone with an interest in the property subject to the mortgage can start an action to get the mortgage canceled and discharged, and seek an adjudication to free the property from that mortgage. And it doesn't matter whether the debt has been paid or not. So this is obviously a pretty important part of our law. The mortgage just can be wiped out. And what you need to show as part of your prima facie case, if you're seeking this relief for your client, is just that the 6-year time limit on enforcing the mortgage has expired. Obviously, you know, you have the same issues of the possibility that acceleration was not acceleration, et cetera, as you did in the prior section. But if you can make your showing that the time has run out and the bank fails to raise a tribal issue of fact about whether the limitations period has actually expired, then the mortgagor is entitled to get the mortgage canceled. That is the law. So you will often see cases where the borrower is simply seeking a declaratory action under RPAPL 15014. These cases that are listed here are all cases where the 6 years ran and the borrower went into court and said, please adjudicate this and order that the mortgage be canceled and discharged. So JBR versus Staples, the Lepore case, the RAC case that was cited in the prior slide, Notar Nicola, and Westbury Properties, which is a very recent case. In addition to these standalone cases, 15014 can also be raised as a counterclaim. So if a foreclosure action is brought and it seems to be time barred, the proper response is to file an answer raising the statute of limitations defense and bring a counterclaim under 15014. And these two cases that are cited are actually the cases he referenced earlier. The Noike case, I'm not sure if I'm pronouncing that right, but 21st Mortgage Corporation versus Noike in Richmond County is Randy's case, and the Harewood case is one that we're litigating here at South Brooklyn. So in those cases, there was a foreclosure action commenced, and we are raising those defenses and the counterclaim. So Calgary is a case that involves just a declaratory action. So there was an earlier case, 2009, dismissed March 2012 for 2000 foreclosure action dismissed in March 2012, and standing was not demonstrated. The borrower started a declaratory action seeking to cancel and discharge the mortgage. And the question in this case was, it's not very clear from the decision, but it seemed as if the plaintiff refiled within the six month safe harbor, but it wasn't very, like as I said, it wasn't clear from the decision. But there was a sense that the important takeaway from this case was that it seemed that the fact that the bank had failed to demonstrate standing was treated as if there was an actual determination of lack of standing. These are two very different things, right? Because we saw that that just a determination by the court that standing wasn't proven is not really a basis to prevent the 205 safe harbor from coming into effect. So that's why the court dismissed. We saw in another decision that safe harbor applies. If there was a lack of standing, though, and a determination that there was a lack of standing, we saw in those earlier cases that Randy talked about, the Burke case and the Suarez case, that acceleration was ineffective from the start. But this case, Calgary, seems to say something different. The Calgary case seems to say, well, if there was a determination that standing had not actually been demonstrated, and that's why the case was dismissed, then there was no earlier acceleration. That, to me, seems erroneous, and unfortunately, that's actually what's happening in the Harewood case that we're litigating. The statute of limitations defense was rejected because there was a failure in the earlier case to demonstrate standing. So some of these cases are a little confused, and it's not surprising because the situation is confusing. I know we're running out of time, so I want just to cover a couple of small things. Here's a list of issues to screen for. So obviously, you want to sort of find out if the default was more than 6 years ago, if there was an acceleration, whether by letter or by action, whether there was any kind of revocation of acceleration, which we haven't really seen, whether there is a standing issue in the prior case. You really do have to sort of interrogate whether that is going to be something that the other side could raise in response to a statute of limitations defense. Was there a bankruptcy somewhere in here that might have told the filing or might have reset the clock? And is there actually a new foreclosure action? Because if there isn't, you don't really have to worry about this defense, but it might come up. You might be able to see whether you think the bank is going to file a new action. Is there a new 90-day notice, etc. So those are the primary screening questions. But please remember, you can waive the statute of limitations defense if it's not timely asserted. It happens. It is not something that will always be available to you if you don't raise it timely. When you're raising the statute of limitations defense, definitely want to raise that 15014. And finally, among the factors, you should include a claim for attorney's fees. As long as you're raising a counterclaim, you should also be raising your client's entitlement to receive attorney's fees. So it's not necessarily going to be granted, but you should definitely recognize that there is entitlement to attorney's fees for a prevailing mortgagor with a counterclaim like this one. Just want to raise at the very end this idea of the free house objection. Obviously, many courts and others find the whole idea of getting out from under a mortgage just because of quote-unquote a technicality somewhat unpalatable. So some might look at the statute of limitations defense and the RPAPL 15014 and say, that's not fair. Someone shouldn't be able to get out from under their mortgage just because the time ran. Obviously, statute of limitations, they exist for a reason. Limitations period are meant to give parties the finality and the ability to have repose. So it's statute of limitations are not only in this context, and I think it's very difficult politically maybe to make the argument, and you really should just recognize that you've got to invoke broader legal values and standards in order to show the courts, look, this isn't about a free house. This is about how the law works and the rule of law. Okay, one last thing. Even if you get that mortgage canceled, your adversary could still seek to get paid for the escrow that they paid out. So that's, if they were paying, the homeowners' property taxes and homeowners' insurance all this time, they could very well be entitled to get that paid back, even if the mortgage itself is canceled. And the Mavane case did involve just that issue. So please be on alert that you should advise your client that even if they do get their mortgage canceled. They could still be on the hook for a lot of money for their escrow. That is it for me, and I'm sorry that we went over, but Randy and I could take some questions.
So it looks like at the moment we don't have any questions, although maybe we can pause and you can give us your email addresses while folks type in any questions they may have.
Would it be easy to just type it in the question box?
Yes, that would be.
Okay. Okay.
Make sure you send it to all. Or perhaps put it in the chat box, actually, that might be easier even.
Okay. I'll do both.
I don't see my chat box, but maybe I'm just missing it. Do you see it?
I can.
Randy, can you?
Yeah, it's on the bottom here. I can send yours as well if you want.
Oh, I see. It just wasn't. It was minimized.
Oh, okay.
I can do it.
Okay.
Okay. So it looks like some of the issues that are coming up are just simply there's some security settings and they're not able to download the documents, which for those that it works for, that's great. For those of you that it's not working for, we will do it, I guess, the old-fashioned way and just email it to you. So Michelle is collecting those email addresses for those of you that are not able to download it. So please include your email address if you have not been able to get access to those documents. Okay, so here's an actual question about the substance. Do the same rules apply for tax liens as well?
Well, CPLR 213-4 specifically is for mortgages, so I think the answer would be no.
Right. Yeah, the property tax rule is a completely separate topic, which, for the record, I believe in August or September, I have to look again at my schedule, but we will be having a webinar about property tax foreclosures, so stay tuned for that one.
You can definitely look in CPLR 213 and see if, because there are several different, that section covers all the 6-year limitations period, and see if there's a basis to determine whether the tax liens are covered by that as well. But
that's a great idea.
Yeah.
Okay, so I don't see any other substantive questions right now, but I would like to put in a plug for our next webinar, which is actually in 2 weeks. It'll be foreclosure actions brought in federal court. Many of you have known this has been coming. For some of you, you've been dealing with this for quite some time. For others, we have not yet seen it come to our county courts. But it will be a webinar that's open to the entire state. They always are open to the entire state, but most of these webinars are sort of a repeat of a session that's been done in person in New York City, and then I hopefully am able to get those trainers and present that same topic to those of us in upstate. This one will be done first time for everybody across the state on July 29th between 12 and 1:30, and again, it's the foreclosure actions brought in federal court and how to handle those cases and what kinds of defenses and claims can you bring because they're bringing it in federal court, which really is an attempt to thwart the 3408 requirements, the settlement conference process. So stay tuned for that one. Randy and Sarah, thank you so very much. This is incredibly dense and helpful, and I appreciate your time and your willingness to share your insight and your expertise that you have developed. So everybody else, have a nice day.